Hi, this is Julie Davis, and I'm here again with Cesiley, and we're going to talk a little bit about patent marking. Certainly, we continue to see a lot of developments in this area, and we continue to see a large number of lawsuits brought against patent holders for falsely marking their products. And it seems like the risk of litigation for false marking might outweigh the benefits of higher patent damages. Can you explain to us why enterprises might continue to mark their products?
Certainly. Patent marking is not something we really saw lawsuits for, at least I don't remember seeing a whole lot of them, but within the last 6 months, we've seen a real increase in the number of lawsuits brought against patent holders. For the people bringing the lawsuits, there's a potential for up to $500 per article in damages. And for a patent holder who's improperly marking their products, that is actually a pretty significant risk. Some cases have come out and, awarded something like a penny per article because the numbers would be just astronomical, and they take into consideration a bunch of different factors. But largely the courts are looking at whether or not there's an intent to deceive the public when the patent marking is applied, because the public policy behind the marking statute is that when somebody has a patent, they have the right to exclude others from making, using, and selling. But at the same time, if you're marking a product to show a patent number or to say patents are pending, and the patent doesn't actually apply or there are no patents pending, you might actually deter further scientific research, which would be bad for technology. You could dissuade competitors from entering the marketplace, and you could cause people to have unnecessary costs as they would try to design around something. So that's the policy behind the marking statute. And as a practical matter, they really seem to be focusing in on that intent to deceive aspect. Now, having said that, if you're a company making a product that costs $5 a product, and you have the potential of $500 per product for mismarking, that's a little bit daunting, and that certainly might lead you to think that it's not worth putting the marking on there. However, I would encourage people to talk to their attorney, think about the commercial pros and cons about whether the ability to get triple damages for patent infringement in their commercial setting makes sense, because if you're in a very litigious area or there's a lot of infringement activity, you want to try and get damages from the earliest possible date, which is going to be the making and using and selling time, as opposed to when you send a cease and desist letter or when you file a lawsuit. So the patent marking allows you to roll back those damages to a much earlier date, which can be quite beneficial. So it certainly may be worth the effort, but it's something you want to carefully consider as a business, and not just be afraid of the fact that there are these people out there who are filing lawsuits.
So it sounds like there's really a lot of important benefits to marking the products with patent numbers, but is there anything that companies can really do to minimize the risk?
Absolutely. These cases really seem to turn on whether or not there's an intent to deceive the public when you actually put the patent markings on there. And it's an individual case-by-case inquiry, so it's very factual. One court has found that knowledge of the fact that your products were mismarked and then failure to take any action was enough to establish an intent to deceive. So you want to, when you find out that your products are mismarked, you want to put in place some corrective action pretty soon. The first thing that we would recommend that companies do is review your current products, to see if any of your products have patents. Any patent marking on them. If you've indicated patent pending and there aren't actually patents currently on file that are pending, you want to take that marking off. If you have issued patent numbers listed, then you want to check those to make sure at least one of the claims applies to that version of the product. Sometimes people will apply patent numbers to an earlier version, and then they'll make product changes, and they won't go back and recheck those patent numbers against the current version of the product. Another thing that can happen, especially for younger companies, is they put patent pending on right away. They file a bunch of provisional patent applications, and then for whatever reason they may not convert them, or applications are going abandoned because they're making business decisions to use their funds elsewhere. If that's happening, you want to make sure you pull that patent pending notice off and somebody's actually checking that. For companies going forward, you want to have a formal process for reviewing this. If you have any sort of labeling process that often will go through multiple departments, you want to have somebody responsible of reviewing label changes and signing off on the correctness of the patent marking. You can do that with your patent counsel. A lot of times the R&D people are quite helpful in making sure that the patent numbers apply. If there's any change to the product, you want to trigger having the product labeling or the product itself changed. Some products are actually marked directly on the product, so if there's like for example a dye, you're not going to change the dye every time patent number adds or comes off, so you'll probably do that on a more timed basis. And then if there's ever a question about whether or not a patent applies, you want to have a process for including your legal counsel and reviewing that to get that final check, because that'll show that you're using a good faith effort to get accurate patent marking and keep that information up to date, and that really helps with whether or not you had the intent to deceive the public when you engaged in the patent marking.
Cicely, that is so helpful. Do you have any suggestions for companies who have licensed in a patent application or are required to mark their products under a license agreement?
That's actually a bit of a tricky situation, because many people have licensed in technology, and part of the license agreement often covers a requirement of patent marking. So I would encourage companies that have any kind of license agreement to go back, look at the license agreement, figure out what the patent marking requirements are, and then make sure that they have established a marking system and review process. Going forward, we would recommend that people entering into license agreements try to put in some sort of indemnification provision. And that could be particularly important for a smaller company who may not have the funds to fend off a patent marking lawsuit, since they seem to be increased in the number of filings. As a practical matter, you're going to have to allocate the risk of early on in the process and the size of the parties, and so the licensee may need to take on more risk than the licensor, but it's certainly something you want to be very cognizant of when you're entering into the license and negotiating it, and think about the respective positions. So that's something that we would definitely recommend people do.
So helpful. Thank you for the update on patent markings.
You're welcome.